Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss latest updates on immigration, frequently asked questions on H-1B, and other immigration matters. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in few minutes. Before that, I would like to repeat the disclaimer. Please note that the show is not intended to provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV News, our agents, are not responsible in any way for your actions. Use the information at your own risk. Also, if you would like to reach the attorney for private consultations, please reach Prashanthi at 212-354-1010 or prashanthi@reddyesq.com. Hi Prashanthi Garu, how are you?
Hello Ranjit Garu. Good, thanks. How are you?
I'm good. Thanks for asking. So, we have few topics to discuss today. The latest topic that's going around the news is that there is a new proposal, the interim final rule to implement new H-1B restrictions. So could you please, throw some light on this and what's happening and, what's the proposal actually meant to be?
Right. So recently we have noticed that H-1B RFEs have reduced a little bit. This is basically because of a lawsuit that was filed, USCIS ITServe versus Cessna. And as a result of this lawsuit, there was a settlement, and then that was followed up by a memo from USCIS, and where they basically said that the right to control information that is being asked in the RFEs, that cannot be asked anymore. So for those who don't know, right to control is basically they want to see an employer-employee relationship between the beneficiary and the petitioner, the company that's filing the H1. And sometimes when the employee is working at a different workplace, for example, at the client side, they're often saying that there is no employer-employee relationship because they're saying an important element or the only element that has to be looked at is the right to control. So since he's not working at your office and you don't have the right to control him physically, so therefore the employer-employee relationship doesn't exist. As per common law or with reference to other law, employer-employee relationship is usually defined as the right to hire, fire, or control. It's not, you don't have to have all the elements. So they were basically, USCIS was asking for all the elements to be present, and thereby they were, going against common law and, common sense also. So as a result of which, this organization called ITServe filed a lawsuit, and they were successful because the judge agreed that the USCIS cannot change the law or cannot make decisions without actually making a rule, publishing a rule, and then opening it up for public comments. So there were many reasons why the judge agreed with them. As a result of which they had USCIS published this memo where they eliminated this whole definition of employer-employee relationship. And so it had become much easier for employers to file H1s because they didn't have to show this onerous documentation of contracts, employment agreements, purchase orders, letters from clients with specific language with reference to right to control. So all that has been eliminated. But then what has happened now is they have tried to impose all those restrictions again. So they're trying to bring back the employer-employee relationship with reference to right to control, and also formalize the other big problem we have, which is specialty occupation definitions. This is the other thing the USCIS has been doing and continues to do, because there hasn't been any lawsuit that has been successful so far. There's some pending lawsuits with reference to specialty occupation. So basically what USCIS is saying, and this is again their own interpretation, is that if profession requires a bachelor's degree in more than one field, for example, if a systems analyst position requires can require a bachelor's degree in computer science as well as engineering, then they're saying that is not a specialty occupation. And that is not the old definition, what the definition is that we know as per law of what the specialty occupation is. Specialty occupation is any position that requires specialized knowledge and which requires a bachelor's degree in a specific field. But specific doesn't mean that it has to be one field. It can mean that it can be several specific fields. So this is the interpretation. They're playing around with that interpretation of the law. So I guess in this rulemaking, they're trying to clarify that as well. They're trying to clarify specialty occupation, and they're putting it in writing that specialty occupation means that there should be only one degree required. And if it's more than one degree, it's not specialty occupation. So they're trying to formalize what they have been doing in practice. But they're doing this in an interim final rule, which means that when you're doing a rule, going ahead with the interim final rule. So there are two ways of making rules. Either you can publish a rule in the traditional way, whereby you have to put it in the Federal Register and then open it up for comments from the public, because the rule should not be against public policy. You have to take comments from agencies, from people, individuals, companies. Everybody is allowed to comment. That's the traditional way of doing it. And that usually takes time because you have to publish it, then you have to wait for comments, then you have to respond to those comments, and then you have to, finally publish it in the Federal Register. They have skipped that because that can take several months. And election coming up, we know everything happening with immigration has a political agenda now. So with elections coming up, they don't have the time to do a traditional publish a traditional regulation. So they're in a traditional way. So they're doing an interim final regulation, which means that comment period is not required, and it can be published immediately to be effective immediately.
Does this mean that whatever USCIS earlier implemented a few regulations or rules through memos, they are going through all those things through the rulemaking process, making it a fail-proof?
Yeah, they're trying to, so that it can be foolproof and people can't file lawsuits. But that they're not really meeting their agenda, because first thing is, if the regulation is against the law. So a regulation is a rule which helps to implement the law. The law is passed by Congress. The president cannot pass a law. They are only implementing the laws that are passed. So a regulation is supposed to be, a method of implementing, rules to implement what the law is. So via the writing the rules, if they're changing the basic law, then that is again unconstitutional, ultra virus. So that itself can lead to a lawsuit, whichever way they do the regulation, even if they do it in the traditional way. That itself can lead to a lawsuit. So they are not helping themselves there. And second, by doing it in an interim final regulation where there's no public comment period, that is really open to lawsuits, because you can only do such a regulation if you show that there is an urgent need right now and time is of the essence and it has to be done right now.
This could also attract a lot of lawsuits. That is what we are hearing from, a lot of attorneys. So what do you think, if they are pushing this through interim final rule without notice and comments, will this be going to be a nightmare for the H-1Bs as well as,
Yes, at least, yeah, in the temporary run, we don't know what will happen with the lawsuit. They can cause a lot of harm while the lawsuit is pending, because even if they immediately file the lawsuit, which they might, the thing is that the judge has to grant an injunction so that the rule is not applied. So they may or may not do that. So if it goes to the merits, it might take some time, right, for the final decision from the judge. So yes, it could. It's definitely a nightmare for all those people filing for a H1. But I'm hopeful, because not every law that goes to the ombudsman is sent to the ombudsman for review is actually published. So I'm hoping that it won't get published. I'm just hoping, but let's see, how things go. We will know very soon.
Another topic we have a lot of people are asking is about cap gap. So could you please, let us know what is exactly gap and, who can use it and, how exactly it works?
Right. So basically, cap gap is for, if, for example, what would happen in the past is if you filed a H1, and when you're filing for at the consulate, and when you're filing for basically under the cap, basically you're filing in advance. So you're filing 6 months in advance for something that's starting October 1st. So in a lot of cases when people were in the United States, they had to maintain their status for 6 months for that period until the H1 actually got approved. And what was happening is a lot of these students who were filing a change of status from F1 to H1 were not able to maintain their status because in that 6 months their status was expiring. So they would have to then, take additional classes, maybe take a separate, enroll in school again for a separate degree. This was extremely expensive. So in order to avoid that, because this was an artificial situation created by, the unavailability of H-1B numbers, people filing on the first day of availability, the numbers getting over on the first day, and then having to wait, 6 months after that. So USCIS came up with the rule that as long as you were in status when you filed, until the time that you actually get the H1 or the H1 gets denied, you will continue to be in that status that you were in when you actually filed. So for example, if you were in an OPT status when you filed for the H1, then throughout that period until your October 1st comes up or the H1 gets approved, whichever is later, you will continue to be on that OPT status even though your OPT expires. So it was an artificial status granted to students. That's what the cap gap is. If you were in your 60 days grace period at the time of filing, which means that you were not authorized to work as of the time of filing the H1, then you don't have to leave the country, but you cannot work because you are not in your authorized OPT period at the time of filing. So these are some of the nuances of the cap gap. In order to qualify for the cap gap, all you need to do is provide the student designated student officer, DSO, with a copy of the H-1B petition and then the receipt when it becomes available, and then they change your status in civis to cap gap, and then once it's approved, they again change it in the civis so that it's reflected that they are now on a H1. So that's pretty much in a nutshell how it works.
So will the DSO issue an I-20 for the cap gap, or is it something different?
No, they don't. It's just recorded in their civis, and also as a result of which you can't travel during a cap gap because it's an interim status that is provided. It's not actual status where you can change your status or do something different.
Okay. Another question is the follow-up. Can they work on the cap gap? Let's say their OPT just expired and they are waiting for the H1 to kick in on October 1st. Will they be able to work on the cap gap?
Yes, they can, but provided, as I said, whatever status they had as of the date of the H1 being filed, that will continue to be their status. Okay. So if they were on OPT, even though the OPT expires within the next 6 months after they file, it will be as if they are in OPT. So yes.
Okay, got it. They can work, but they cannot go out of country. That's one thing. And another question is, what happens, let's say this cap gap you said is only until September 30th, and as soon as the H-1B comes in, that's H-1B will take over. But then sometimes in situations, the H-1 won't be approved until sometimes November, December, sometimes even goes into the next year. So what is the situation, when such thing happens and H-1 is not approved even after October 1st?
So that it becomes a problem. If the H-1 is not approved by October 1st, then that gap, that artificially created status no longer exists, right? That this is a nuance of the gap law. That artificially created status no longer exists. And then as of October 1st, they have to get on to, either they have to take classes again, so they have to change their CVs and become a student again, a full-time student. So they have to then continue taking classes in the summer or whatever it is. So they have to continue their status and plan for that. Because if they don't, then there is no gap. And if their status has not expired, it's fine, Ranjit. For example, if they're still on OPT, then it's fine. They can continue. Or they're on CPT, or they're just, a full-time student, they can continue. But if they are not in any other status and they're only dependent on the gap for their status, then unfortunately they'll have to change status or get into some kind of a valid status before October 1st, which is basically, take additional courses on their F1 status.
Or better, they upgrade it to premium and get the result faster. So, you don't have to go.
Yes, but usually in the past, premium has never been available for cap cases. Only recently it has become available. So if premium is available, of course, that's a no-brainer, they should do that. But if that's not available, then they have to either leave the country and then come back, just to consular processing, or, stay back and then continue to take classes and safeguard their status.
Okay, another question, let's say they are utilizing the gap and unfortunately the H-1B is rejected for some reason, or let's say H-1B is approved only as a consular process. What are the steps they have to do? Can they stay for a bit, or they have to leave the country, or what options do they have? Can they change the status to another visa, or what options do they have?
So if after being granted the gap extension, H1 is rejected or denied or revoked, then they will have that standard 60 days grace period. And then, before they are required to depart from the United States, they have given them that. Because then it becomes, very sudden, and then for them to leave suddenly also is a problem. So with that 60 days grace period, then they should be able to revert back, to an F1 status, as I was mentioning earlier. And then, maybe file for the cap next year. So that they do have that option.
Okay, got it. So, they have a 60 days time in which they have to decide what to be done and then take a decision. Another question, do they have any grace period for OPT? Let's say someone's OPT is expiring, let's assume in November. Do they have to leave immediately after the OPT expires, or we heard that there is a 60-day grace for the OPT as well?
So there's no 60-day grace at both times. The 60-day grace, before they apply for an OPT, they have 60 days grace. If they don't use it, then they have 60 days grace after the OPT is over. So you don't get two 60-day grace periods. It's only one 60-day grace period that you get, that you can make use of to file, from an F1 to a H1 or whatever it might be.
Can they work during this grace period? Even let's assume if it's a gap grace.
No, it's just a grace period which allows them to change or extend their status.
Okay, so they cannot work in that period.
Correct.
He is going to file green card through marriage, but then he's on H-1B and he's about to file the green card on the basis of the marriage, but he just lost the job and out of the job for a month. So what happens if he applies for the green card based on the basis of marriage? So will this 1 month of whatever the period he's not on job, will it affect the green card in any way?
So it depends on what basis he's filing for, if he's married to a US citizen or he's married to a permanent resident. That makes a big difference.
US citizen.
If he's married to a US citizen, then even if he's out of status, he can still adjust. That is the only exception. Immediate family members can adjust, even if you're out of status. But if you're marrying a permanent resident, for example, then you have to show that you're in status as of the date of filing the adjustment of status application. But if you're married to a citizen, even if you're out of status, As long as you entered legally, you entered with inspection, you can still adjust. So this applies to children of citizens, spouses, or parents, all immediate relatives.
Another question, a follow-up question is, because now there is no job there, someone has to show that they are sponsoring, or either the wife or someone has to show some money or sponsorship that they are sponsoring the GC. So is that the case, or who can support this? Let's say even the spouse is not employed or not enough salary. Let's assume they don't have, probably they only have, let's say 20,000 or 30,000 a year. So what options they have, and who can show the sponsorship option?
Right. So recently, of course, that has become much more important, and it's extremely critical for approving of the case itself, because of the new public charge law, which was implemented for some time, and right now it is not being implemented, but it might come back. So yeah, it's very important in an adjustment of status case to show that you will not be a public charge. So even presently there is a limited, it is not as expensive as what we had, but we still, as you said, you have to show that the person will not become a public charge. And that is usually done via an affidavit of support. So usually the person who's sponsoring, like the US citizen spouse, will fill out an affidavit of support saying that, their spouse the beneficiary or the spouse will not become a public charge, and they'll take care of them. But in order to do that, the spouse who is petitioning has to have a job or source of revenue or something. So if they don't have a job, then the alternative is to have the beneficiary spouse, if that person has a job, suppose he's on a H1, like you said, he or she, then the beneficiary spouse who's on a H1 can fill out an I-864A as a joint sponsor. So that is possible. If both are not working, then it's possible that a family member can sponsor. So the family member has to fill out a separate affidavit of support or I-864. It could be a parent, a relative. It can really be anyone who is swearing to, make sure that you don't become a public charge and is responsible for making sure you don't become a public charge.
Okay, so someone should say, whoever has earnings or income has to say that they will support and will not be a public charge.
Right. So the income has to be above the poverty guidelines. So the poverty guidelines are some 25,000 per year for a family of 4. So it's not a very high mark for many people who are earning, but for people who are not doing professional jobs or doing menial jobs, it might not be easy to reach that annual salary.
Okay. Another follow-up question here is, let's say they don't have enough, whatever the money you said, and they filed the application, but then after a few days, the H-1B, he got the job, whoever was an H-1B, applied the GC. So will that be okay if they send the
yeah, because you can always update at the time of the interview, or if there's an RFE, you can always update, send a new I-864 with the new information and the new pay stubs or employment letters. So you can always update that information.
So another question is about the automatic visa revalidation. I know this was possible before the borders closed, and now there is no border. We don't have any borders, but then few people have an option to travel out of the US in flights, especially to Canada or Mexico. So we would like to know about this automatic visa revalidation and how exactly that works.
So now what I mean by visa revalidation is basically you do have to go out of the country. You do have to put your visa and the documents in a Dropbox. But what's being waived is the interview process. And that is not, it is not automatic in the sense, from the meaning of the term.
Yeah, Prashanthi, we have a caller. We'll continue this later. Sujana, I think. Sujana, are you online? Can you hear, Prashanthi? I can hear, but it's very...
If you can hear, then if you tell me what the question is, I'll answer it.
Okay, yeah. Srujana, go ahead. I'll repeat the question.
Okay. So I'm currently on my STEM extension. So recently, I have shifted my employer from employer A to employer B. So after my switch to the employer B, I came to know that my H-1B, which was applied by employer A, has been picked up in the second attempt lottery. So now my question is there any possibility that can I make use of the H-1B picked it through employer B? Will there be any kind of possibility, or should I rejoin employer A and go with them? What do you exactly suggest?
Yeah, so she says that she is in STEM OPT extension, and she moved from an employer A to employer B. After moving, in the second lottery, the H-1B got picked from the employer A. Now she is asking if there is any possibility that she can use that H-1B for employer B, or she has to go back only to the employer A.
Right. No, the lottery, the numbers are allocated as per the employers. So if it is allocated via employer A, then if you want to file that H1, you'll have to move to employer A at least as of October 1st. Or whenever the H1 gets approved. So if you're willing to do that, you can go ahead and file the H1.
So I think you got your answer, Sujana. So you only can utilize the employer A. So if you still have a job with the employer A, you can go with them and continue working for employer A and get the H1B approved. And you can start working on H1B from October 1st or, whichever the date the H1B is approved. And you can always move out to another employer after October 1st. That is right.
Yes. So she doesn't have to start immediately with that employer. Just file the H1 because you have to file it before November 20th, right? So just file the H1, and if it gets approved, then as of the date of approval or October 1st, whichever is later, you have to start working for that employer.
Okay, we have another caller, Pankaj. Let's take the call. Hi, Pankaj. Welcome to the Immigration Talk Show, and you are on the air. You can talk to the attorney and ask your question.
Sure. Hi. Thank you so much for taking up my question. I'm having question for E3 visa change of employer. My E3 visa validity is 1 year left. I-94 is also 1 year left. And now if I change the employer with the new approved LCA, can I work straight away with this employer till 1 year? And as soon as my visa gets near to expiry, I will basically go with my approved LCA or 1 year old one, and with the pay slips and all those things to the border. Will that be okay?
So if your question is, can you file for an extension or a transfer for an E3 while you're in the country? Yes, absolutely you can. You can do that. It's just a different process, and it's a little bit more complicated than the usual way that we do the E3, which is going to the consulate and getting extension or change of employer or whatever it might be. That's usually easier, but now because of traveling being a problem, we are filing extensions or transfers within the US with the USCIS. So yeah, it's just like filing a H1 transfer or extension. You can absolutely do it. You have to file the I-129 forms along with the LCA. So it's a different process, but it can be done, yes.
Okay, we have another caller, Neetu. Hi, Neetu. Welcome to the show. You can ask your question. You are on the air.
Yeah, I'm here. Yeah, my question is related with H4EAD biometrics. Like it's almost like 6 months for me. Like I have filed in March, but like still there is the same status. I mean, it's not moving. And whenever we are trying to call USCIS, they are just extending the timeline. Like 60 days, it's become 90 days now. So any idea about the biometrics or any changes you are seeing in near future?
So we are getting biometrics now for H4EADs. We're getting biometrics appointments. But in general, those H4EADs and H4s are taking 6 to 8 months to get approved. Very long waiting period. And our suggestion is If it is, more than 4+ months, well, you have to do certain things first, which looks like you've done. You have to, call or email USCIS for your case status. You can approach your local congressman and ask them to check up on your status. They will do that. Every congressman, senator will have an immigration department, and they do that frequently for their constituents. The third thing to do is also follow up with the ombudsman's office. It's very easy to do that. Email them and with all your information, and they will keep following up on your behalf with USCIS, and they keep sending you weekly or monthly emails that they have followed up, and this is the status, this is what they have said. So they even send you sometimes weekly or once in 2 weeks, they will send you emails. They're pretty good. So if all of that is not working, then the other thing to do is a mandamus application with the federal court. Basically, a mandamus application is you're forcing the government to make a decision on your case within a reasonable period of time. So if something is taking a long time, you're telling the judge to ask USCIS to adjudicate your case in a timely manner. And you will show them you also have to show obviously that you have done everything else possible to follow up on your case, and you also have to show what is the harm that is being caused, loss of job, etc., by them not adjudicating it on time. So that mandamus is actually easier than most people think. It's something that can be done. A lot of people have done that, especially in the H4EAD situation. Something to consider for sure. It's not as prohibitively expensive as people think that, as soon as they say lawsuit, they think that it's in $10,000s of dollars. So it's not necessarily the case.
Another caller, Mohan. Hi, Mohan. Welcome to the show. Please ask your question.
Yeah.
You're on the air.
Yeah, hello. Hi. My name is Mohan. So I have one question. My wife was on STEM OPT, STEM OPT, and unfortunately, when we applied for extension, it was rejected for stating some reason. So then, within 2 weeks of time, we have submitted one. I think I'm on H-1B and I have 140 approved. We have submitted H4 and H4EAD. So our law office has filed through non-pro processing, NP non-pro processing. So I think so. It's now it is pending more than 105 days. So 105 days, and we only have until October to be here. To be in US. Otherwise, my law office told we will fall in the 3 years ban period. So what you feel the best way to do here?
I think in your situation, if it was not for COVID, I would just blindly tell you, don't even bother to file nunc-pro-tunc change of status, especially for a H4 situation. Just leave the country and come back. Apply for a H4 and come back. But unfortunately, in the situation that we face today, where consulates are closed and travel is difficult, I guess you had to take that step where you filed, rightly so, filed the nunc-pro-tunc change of status. The only thing I can tell you is, I guess because of the biometrics and in general, processing time is for H4s and H4EADs, as I said, it's taking 8 months. So it could be that, so you will go beyond that 6-month period. If it gets approved, it's fine. So it's a risk, right? If it gets approved, it's fine. Everything is forgiven. But if it doesn't get approved, and then you're forced to leave, and if it goes beyond 6 months, the decision, you come to know the decision after 6 months, then you will be unlawfully, you will be barred from re-entering the country for 10 years because of that whole unlawful presence law. I mean, again, it's within the discretion of the consulate whether they apply it or not, because I've seen in the past in H4 situations, they have not applied it. But again, it's a risk and no one knows what the result will be. Maybe the best bet is before the 6 months is getting over to leave, and then either apply where the consulates are open in Canada or Mexico, or go back to India and wait for the consulates to open up, or ask for an emergency visa in India. But definitely, I think the best situation would be if you don't get any response with reference to your wife's case before 6 months, then you should leave. I mean, your wife should leave and then, apply via consular processing.
Okay, I hope that answers your question. Okay, going back to the automatic visa revalidation that we were talking, how does it actually work?
So so that's what it is. What they're calling automatic visa revalidation is you have to put the passport in the box and then submit your documents, and they will look at it and they will decide if it's discretionary again. So just because you put it in the drop box and you qualify for it doesn't mean that you won't be called for an interview. So it's possible that you'll be called for an interview, or it's possible that they'll waive the interview. So that's how it pretty much works. But in the past, visa revalidation was meant that there was no interview period. You didn't even have to leave the country. You could simply apply with the Department of State here in the US, send in your passport for a visa revalidation, and they would stamp the passport and mail it back to us. And that was really visa revalidation in the true sense. So when they say automatic visa revalidation now, I'm like, what does it mean, So I don't see any benefit really if you have to leave the country anyway and it's discretionary after that. But I mean, what we've heard is because of the consulates being closed across the world, they have extended that. So usually the visa revalidation that we're talking about is if your visa has expired within 1 year, then they say that you qualify for visa revalidation. So you have to leave the country.
We have a caller, Rajesh. Let's take the call and then we can continue. Hi, Rajesh. Welcome to the show. You can ask your question. You're on the air.
I am on L1A visa right now from February 2020. And I've got H-1B petition which was approved on 2014-15 lottery system, which was never used. I never used it for stamping. Due to some COVID situations, my company may ask me to kind of leave the country because the project is not there. I'm just trying to see if I can use my H-1B petition, which was there earlier, to kind of convert my visa status.
Right. So the change of status you want to do from L1 to H1, and you're trying to find out if you're cap exempt because you previously had a H1. But if you have never used that H1 before, if you have never been on the payroll after that H1 got approved with that particular employer, even for a day, then it's possible that USCIS might take strictest interpretation of the cap law, and they might say that you don't qualify for a cap exempt case because you've never actually worked on that H1. But if you have the luxury of doing it and if you have the time and if you're not falling out of status, then I suggest there's no harm in trying to file a change of status from L to H and do it premium processing so that you get a response quickly and you can leave in case they say that you're not eligible for the cap exempt. So what I'm saying is it depends on the officer. Most of the times it doesn't work, but sometimes it might. So there's no harm in trying.
Okay, Rajesh, hope that answers your question. So I have a question that we got offline. Let's say the H-1B that's picked in the lottery and it's already approved. Let's say it got approved even in July itself. But then the question is, can they transfer it to another employer because it's already approved in July and they don't have to wait until October to kick in? Or they can transfer until October 1st? What is the exact scenario?
Yeah, so good question. So if it is before October, the person is not on a H1, right? So there's no question of a transfer. The person is on their previous status. So you have to file a change of status from that status, say F1, again to a H1. So if you have to file a change of status from an F1 to H1, again, the question arises is if you're cap exempt. Again, the same thing. If you have never worked on that H1 yet because it's at a future date, then you may not be cap exempt. because the H1 is not yet. Two reasons here. The first thing is the validity of the H1 is sometime in the future, and the second thing is you never worked on that H1, so they may not interpret that as being cap exempt.
Okay, got it. Another question is, what happens, let's say employer revoked the H-1B before the October 1st even got in. I mean, they thought the project would come in, but then because of some circumstances, or especially in this COVID scenario, they don't have it now, or they don't have any job. So, and they revoke the H-1B after it's approved before the October 1st. Can they use that H-1B or no?
Again, same thing. If they have not worked on the H1, even a single day, for example, if they revoke it on October 2nd, then they're cap exempt because they worked for 1 day on that H1. But if they have not worked at all, because it was again October 1st and before October 1st itself it's revoked, then arguably it's not cap exempt. That is how they have been interpreting it in the strictest possible fashion. But again, there's no harm in trying. At the most, you lose your USCIS fee. As long as you're not jeopardizing your status by trying, I would suggest to try.
Okay, got it. So we have a couple of questions regarding the E3 and TN visas. Could you throw some light on what E3 visa is and who are eligible for E3 visa, and what is a TN visa and who are all eligible for TN visa?
So E3s and TNs are good substitutes for H1, especially when the cap is over. But unfortunately, you have to be a national of a certain country to be eligible for either of them. So for the TN, you have to be a national of Mexico or Canada, and for the E3, you have to be a national of Australia. So you don't have to be born in those countries, but you have to be an Australian citizen or a Mexican citizen or a Canadian citizen.
Hold their passport, hold the passport of the country, right?
Correct. Yes, correct. Then you qualify for those visas. In the TN visa situation, there is a list of NAFTA basically has provided a list of occupations that qualify for TN. So as long as you're within those occupations, and they've also, along with the occupations, given who qualifies, like what degree you need to have, what education you need to have in order to work in this profession. So as long as you, number one, are working in that profession, have a job offer in that profession, or number two, you also have a qualification based on the list that they have given, you qualify for the TN. So it's different from a H1. You don't have to show that you have a bachelor's degree, or it really depends on, for example, in the IT professions, there's there's an engineer position, and it says you have to have a bachelor's in engineering. It doesn't say necessarily computer science. So it's a little bit different from the H1, the nuances that they have with reference to specialty occupation. The problem with TN is there is a limited intent to dual intent problem. On a H1, you can, have a green card application pending and be on a H1 at the same time, and there's no issue. With a TN, there can be an issue with reference to intent if you have, say, a green card pending, either family-based or employment-based. So when you apply for it, when you're outside the country and you're trying to come back in, get an extension, then it's possible that you have a green card pending that they may not give you the TN, unless you're able to show that there is no intent. So that's kind of hard. So for the E3, this is again for Australian nationals, Australian citizens, and they pretty much follow the same rules as specialty occupation. So basically, if it's a specialty occupation for a H1, you qualify for the E3 as well, and it's the same rules as to which job qualifies for a specialty occupation and which doesn't. So pretty much that's an E3 that can be again granted outside the country. You don't have to apply, unlike a H1 where you have to file and get an approval at USCIS and then go to the consulate. Both the TN and the E3, you can apply directly at the consulate. You don't have to fill out any forms with USCIS here. You can directly go to the consulate, apply, and get the E3 and come into the country.
Yeah. Sorry, Prashanthi, sorry to interrupt you. We have a caller, Dhananjay Reddy. Let's take the call and then we'll continue. Hi, Dhananjay Reddy. Welcome to the show. You're on the air and you can ask your question.
Yeah, thanks for taking my call. Actually, I want to talk to, Prashanthi Reddy about, spouse visa. Actually, my son got married last year, February in India, and we applied for spouse visa for my daughter-in-law, I-130, and which was approved in June last year. And then, she attended interview at Mumbai, this year, February, and she got issued with 221G, and they wanted some additional documentation, which we submitted all the information, and we did not get any update after that. And now it is more than 1.5 years, and we really don't know what to do. What is the best way to move it on quickly?
So I think the problem here is the COVID. Otherwise, you would have gotten something. I think it's COVID related. Number one, the consulates are closed, so they're not processing any cases. So that is causing heavy delays. They can't call for interviews. They can't, there's very skeleton staff in India. Number two is also the fact that they cannot issue you the immigrant visa now because of the presidential proclamation. The first presidential proclamation, if you recall, basically was for family-based petitions, and it said that if you have not yet received an approval or an immigrant visa approval, then you fall under the proclamation, and as a result of which, you have to wait until December 31st in order to, for any visa to be granted. So you've been hit in two ways. One, the consulates are closed, so processing is not taking place, and second is, even if they open up, the visa cannot be granted, the immigrant visa, unless the proclamation is removed, or it dies its natural death, or something happens with the court. There are a lot of court cases, by the way, against even that. AILA has filed a lawsuit against that family-based proclamation. So if some good news comes with reference to the lawsuit, then maybe you can request for an emergency. You don't even need an interview because the interview was already done. So if they are still taking a long time, the other option is, if the proclamation is not in place, file a mandamus petition, which I was talking about earlier. This applies even to consulate cases. So you can, since DHS or Department of State is a government organization, you can file a lawsuit against DHS asking them to process the visa quickly. In the interim, I suggest that you wait until something happens with the proclamation, because nothing else can be done for now.
Yeah, Dhananjay, hope you got the answer. Hi, Prashanthi. Going back to the previous E3 TN visa, so the E3 and TN visas, both of them, you don't need to file an I-129 or any other form like H-1B. So they could just get it. E3, I believe you can just go with, I believe you need an LCA and you have to take the LCA and offer letter with the consulate and get the approval. Am I right?
Yeah. So you just need a LCA approved, and you need what's called a petitioner letter. So the petitioner letter will explain about the company, will explain about the job, will explain what the qualifications are, the beneficiary's qualifications. So pretty much the same as a petitioner letter in a H1 situation, where you have to prove that it's a specialty occupation. So that explanation is needed, and that's usually given in the form of a petitioner letter. So that LCA, the petitioner letter, the educational documents, and an evaluation of the education documents if it's not a US degree. That's what is needed. And of course, an offer letter, employment agreement from the employer.
Yeah, for TN visa, I heard that you don't even need an LCA, just an offer letter at the port of entry would do. Am I right? Or is there anything that's needed for the TN visa?
Pretty much petitioner letter is required. And again, evaluation of the credentials, the educational credentials, to show that they qualify for the TN as per NAFTA regulations. That's what is needed. And of course, the intent question might come up, so you have to be same thing if you went for an F1 or a B2 visa, how you have to show that you have the intent of returning and that you have ties to the US. That's the same. You have to do the same thing.
Okay, I think we are at the end of the show. So, I would like to again repeat the disclaimer. Please note that this show is not intended to provide any legal advice and is very general in nature. It is only for informational purposes. Agents or Sakshi TV agents or news are anyways not responsible in any way for your actions. Please use the information at your own risk. If you have to reach the attorney Prashanthi Reddy for the private consultation, please reach her at 212-354-1010 or prashanthi@reddyesq.com. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 6 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday at 6 p.m. EST on Sakshi TV. Thanks, Prashanthi. Thanks for your time. This is Ranjit signing off. Thank you.
Thank you.